you are in the world, but in just a few seconds, we're live everywhere that's working on the internet. The official start of Ask Andrew is just nanoseconds away. You can tell I do like Star Trek references. Good evening, everyone. I'm Andrew Feldstein. I'm the Andrew in Ask Andrew. I'm also the founder of Feldstein Family Law Group. Our clients are served by 5 offices in the Toronto area. I believe Ask Andrew is the first internet live phone-in show created by a family law lawyer. And since we first started broadcasting in December, I have seen no other law firm in Canada or elsewhere try to do what we're accomplishing. I'm here to answer your questions for free. I will give you lots of legal information. Technically, it's information, not advice. People tease me, doesn't everyone want to talk to a lawyer for free? Well, yes. In the past couple of weeks, I've been a guest on News Talk 1010 radio with Barb DiGiulio. I've been interviewed by a reporter for the Globe and Mail, and the Toronto Star has published a story based on asking me about annulments, which was exciting since here's the story and made front page and back page. So that was fun and gives us some interesting information for our archives. And it was about annulments. And annulments are rare in Canada, and there's a high bar to get a judge to rule in favor of an annulment. I'll answer some questions about the issues in that divorce later in tonight's show. This is our March program. You can see earlier shows by visiting separation.ca. We are finding that many people find the recorded shows useful and are watching them. Because of our national nature of the Divorce Act, most of what we discuss will be useful across Canada. Not all of it, but most of it. Our firm practices family law exclusively. We take our work very, very seriously. Here's how tonight's question and answer show works. Some people have emailed their questions ahead of tonight's show, and we welcome more tonight. I've saved some of the questions reporters asked me in the past few weeks. Phone us. You can phone, which means we can discuss your situation. All you have to do is call 1-800-498-3486. One of our staff will answer your call, ask the general nature of your question, perhaps help you phrase it, and decide on whether you wish to use your real name. Text us. Text your question to 416-303-8307. Email me. Email me your questions to andrew@feldsteinfamilylaw.com. We will not show your text or email on the screen. There's some technical things you should know about. It's a good idea to phrase your question carefully. Here's why. Each Ask Andrew show is recorded by us and by YouTube, and you'll be able to go back and watch the show anytime you want. Bottom line, your question will be around for a long time. Please do not ask a question in such a way that it can identify you. Keep your safety and security in mind. Let's get started. Now we have our first caller. Hi, Matt. This is Andrew Feldstein.
Hi, how are you?
Good. So what can I do for you? What questions do you have?
I just have general questions about, it's not child related, it's just property related in regards to a divorce.
Okay.
Questions are, the mortgage is solely in my name. Understand that my wife's entitled to half the equity of the house or half the asset. How does it work with the debt? Like everything is in my name.
The house is in your name and the debt is in your name?
Yes.
Okay, well, what we start with is you're married, am I correct?
Separated now.
Yes, but you were married. You weren't common law. You actually got married.
Married, yes.
Okay, so that means your wife is entitled to an equalization of net family property.
Okay.
So what happens is we have to add up all your assets subtracted by your debts to give you your net family, to give us what you have on the date of separation.
Okay.
Then you would do the same calculation on the date of marriage. We want to see how much your net worth grew by during the marriage. There are some exceptions like inheritances and large gifts, and if you don't have any of those exceptions, we do the same calculation for both of you. Whoever has more pays half the difference to the one who has less. So in your scenario, if you had all the assets and your net assets are $500,000 on the date of separation, and you had nothing on the date of marriage, and your wife has nothing on both dates, then you owe her half, which would be $250,000.
Okay. Well, the situation is kind of like a little bit reversed.
Okay, how is it reversed?
On her 13.1, she didn't claim any of the house value as an asset.
Okay.
And the debt.
She claimed the debt?
No, she didn't claim anything.
Okay, but you're telling me it's in your name. You said the house is in your name and the debt is in your name.
I understand that she's entitled to half of that.
She's not entitled to half of it. What she's entitled to is the equalization payment.
Okay.
So it's not, there's a fallacy that a lot of people believe that the matrimonial home is automatically divided no matter what. And that's not the case. The Family Law Act is an act that deals with how much money one person has to pay to the other. So what we're trying to do is figure out how much you would have to pay her in an equalization payment.
Yes.
Depending on certain facts, there's an argument to be made where people get into a fight, is that once you separate, who gets to have the increase in the value of the home post-separation?
Because I've been paying all the bills since she's left.
You start with the assumption that if you're on title, it's yours, and therefore you solely have the increased value. Then there are some technical arguments that get into trust law that can allow someone to say that you're holding half of it in trust for them. But assuming there's no trust arguments in your case, it's a matter of what's your net family property in the simplest form, your net worth on date of separation, your net less your net worth on date of marriage, to see how much your net worth grew by during the marriage. And if she has zero net family property, you're paying her half of that number.
Okay.
Okay, so she was right not to put the house down because she doesn't own it. She was right not to put the debt down because she doesn't owe the money back. It's your responsibility.
Okay.
Does that make sense to you?
Yeah. Now I have a question. Do I have more than one question I can allow, or?
Sure, go ahead, Matt.
Okay, I'm disabled and I have an RDSP.
Okay.
She's not claiming it, but the money doesn't vest until 2018. If I pass away tomorrow, the government's taking their money back.
Okay.
I have to declare, what do I have to declare? Is it excluded property?
Well, it's a question. Well, let me start with, is it in pay right now?
No.
Okay, so it's similar to an RSP or a pension, am I correct?
Yes, but I can only be the sole beneficiary because it's related to my disability.
Okay. Now, is it covering loss of income, pain and suffering, or a combination of the two?
No, basically, it's if I contribute, it's like a pension. If I contribute for the first $500, if I contribute $1, the government matches it by 300%, so they give me $3.
Okay. But it's really a question of what is the purpose of that disability pension, because if it's meant to support your disability for pain and suffering,
well, it's to support me when I...
Or is it for loss of income? And that becomes important.
It's got nothing to do with that. Basically, it's a government...
I understand, but you see, pensions and RSPs form part of your net family property.
I don't have RSPs. I have an registered disability savings plan.
I understand that, but what I'm trying to explain to you is all your assets have to appear on your sworn financial statement.
Yes.
And so that has to go in with whatever it's worth on the date of separation. My question is, A, what is it worth? And then B, I'm trying to see if it can be pigeonholed into one of those exceptions I mentioned earlier. To give you an example of what I mean, if someone is in a car accident,
right,
and they get hurt, there's usually two types of damages they get. One is for pain and suffering.
right,
And when you get damages to cover your pain and suffering, that is something that's excluded from the equalization calculation because it's making up for your personal pain.
okay,
Then you have another source of money that you may get from a car accident, compensates you for the loss of income.
well, I got that through my employer through a disability.
So the loss of income is replacement of your income, and that would be open to equalization if you had received the monies by the date of separation. Now, for an income stream that you get post-separation from your disability pension, that's also in play for spousal support or child support. if she wants to make a claim for that, depending on what her income is as well and where the children may be.
If you take my it's non-taxable. It's like a long-term disability non-taxable. I don't get a T4 for it.
You still have to declare it as income?
Well, I don't have a problem declaring it, but I want to exclude it as insurance money.
That will, for the purposes of support, it is not an asset for equalization of net family property. The Court of Appeal dealt with that a number of years ago. However, it is an income stream for support purposes. So depending on what your wife makes, that's an income stream that determines whether or not you would have to pay spousal support or not, and whether she's entitled. And if you have children and they're with her, you may have to pay child support on that.
Okay, so how will it work, and how would it work in my situation when?
Does your wife work?
Yes.
How much does she make? Does she make more than your disability pension?
Well, I collect Canada pension too.
Okay, so you have to put all your income sources in.
Well, we're about equal.
Okay, yours is probably somewhat higher because you would do a gross up on the fact you don't pay taxes. So we'd have to do calculations. Do you have children?
No.
Okay, so she'd have to make a claim for...
That's children, they're not mine.
Okay, well that brings up a whole other issue too. But let's assume you don't have children of the marriage in this particular case, and assuming that if she wanted to claim spousal support, she'd have to establish entitlement, and then if she establishes entitlement, then you would have to look at what you have to pay.
Okay.
I'm not sure if she'll be able to establish entitlement, but certainly if your incomes are somewhat close, that's a good thing.
So basically, according to when I file my 13.1, I don't split the house in half because my name is solely on the house. I take the whole house.
You put the whole house on your side.
And all the debt.
Yeah, exactly. You get the good and the bad.
And then I should be doing this for the valuation date, and I should be doing this for the date of marriage.
Yes.
So she's only entitled to basically the increase in the house since we got married.
There's another, your questions are somewhat like a law school exam, because did you come into the marriage with this house?
Well, we were living together, but not common law when I bought the house, and she made a promise to me when we got married that she would never take the house from me.
Okay, well, I'm not worried about promises, because the family law says for it to be a marriage contract, it has to be signed by both parties. A contract has to be in writing and signed by both parties and witnessed. So
Right.
It wasn't. And did you own this house on the date of marriage?
Yes.
Okay, then you're one of the people that you're not going to like what I'm about to say, because you don't get credit for bringing a house that is a matrimonial home on the date of separation. You don't get to deduct it from your net family property. It doesn't go into that calculation. It's like you never owned it. And that's the reaction you usually get when I tell one of my clients about that. It's shock and dismay.
No,
And
I'm not, it doesn't surprise me.
what you should have done, and people should understand, is if you're getting married or even moving in with somebody, at the very least, get yourself a cohabitation agreement or a marriage contract that specifically says whatever the house is worth on date of marriage, you can deduct it. It's very important. It protects you from what most people think is an unfair piece of the legislation, because had you sold the home and moved into another home, you would actually get the deduction. And that makes no sense from a common sense perspective, but that's what the law is.
Right. Now, if I owe my wife money, the difference between the net family property, right?
Yes.
Do I have an option? Like, do I have to pay her within, because I'm on disability, can I ask the courts to extend that I can pay her over 10 years?
You can, but you're not going to get it.
But the problem is that if I sell my house, because I'm on disability, I won't qualify for another mortgage.
Okay, then you'll have to sell your house. The court isn't going to give you 10 years. The cases when what Matt has suggested is that in the Family Law Act, there is a section that says someone who owes an equalization payment can ask to have it paid over 10 years. It's a very rarely used section, and it's not meant for someone who owns a home and wants to keep their home. What it's meant for is somebody who owns a business, and it creates a very large equalization payment because of the value of the business.
Okay.
What a court does not want to have happen is somebody being forced to sell their business and lose the income stream for the family in order to fund the equalization payment. because that's the asset that pays for everything.
Okay, I just have two more questions.
All right, because I do have other callers on hold.
Okay, what do I do when my wife's attorney won't deal with self-representative?
Well, ultimately he's going to have to deal with you, but you probably should have a lawyer. Some people believe lawyers are going to run up fees, and we're not cheap.
No,
but
I don't have a problem. Like, I can negotiate with him. Like, I just wanted to agree on a separation date, and I wanted to exchange financial information. He just didn't respond to me for over 2 months and just filed court papers.
well, now he's going to have to respond to you because you can do an answer. You'll have to file your financial statement, your certificate of financial disclosure, and he'll have to deal with you at scheduling dates and other things along those lines. And when you come to court, he can deal with you in court. I would suggest, though, whether you hire this firm or another firm, that you should be hiring a lawyer. If you don't have a lawyer, it creates two problems for you. Number one, you're not going to believe anything this gentleman is telling you. And that means it becomes very difficult for you to reach a resolution. And the other place is, you may not appreciate where he's being reasonable or unreasonable. Some lawyers dealing with a self-rep, even though we're not supposed to, may try to take advantage of you. And other lawyers may tell you things that you may believe they're trying to take advantage of you, and they're not. And your case has a much higher probability of resolving itself if you are represented.
Right.
Okay, and if you do need information because you want to do it on your own, then
Financial position to pay an attorney.
okay, well, then you should go visit our website, familylawhelp.ca, because it's a website that helps people do it yourself. And you can also choose whether, as I said, whether it's this firm or another firm, even though I think we're the best firm, to do something called a limited scope retainer. And that would mean you could hire a lawyer to do specific steps in your case. So you could say to a lawyer, I want you to draft the answer and financial statement for me, or I want you to go to the case conference for me and negotiate with this lawyer, but I don't want to hire you on a comprehensive basis so that you do everything for me because I can't afford that. So you can pick and choose where you strategically want to spend your money on a lawyer.
Right, okay.
All right?
Well, one last question.
Okay, Matt.
What happens if the lawyers falsified documents?
Well, I can't answer that because I think what you're suggesting is unethical behavior, and if you're going to suggest that in court, you better have overwhelming evidence. If you suggest it and you do not have overwhelming evidence, the court is not going to be impressed. And that's exactly the kind of reason why I say it's good to have a lawyer. Because if you...
It's just an off-the-topic question. I just think that he falsified something, but I can't prove it.
All right. Well, Matt, I do have other callers that have been holding for a while. So let me pick them up, and good luck with your case. And if there's anything we can do to help you, then please contact us during business hours, and we'd be happy to set up an initial consultation for free with you.
Okay, thank you.
Thank you, Matt. Bye.
All right, bye-bye.
Hi, Alan. This is Andrew Feldstein. How are you?
Hi,
Oh, I thought I must have picked up the wrong name with that. Sorry, Leslie.
this is Leslie.
Leslie, sorry. My apologies.
Okay.
How can I help you, Leslie?
So my question is, as in a situation where there is a marital separation, they're still legally married, and the one parent is primary, there's been a family law case, that a final order has been issued for custody with respect to custody, and there is one parent that has primary custody, the other parent has access.
Do you mean custody or...
My question is, as the non-custodial parent, what things can you do to sort of prepare yourself and arm yourself to go after further custody in the future? So how can you set yourself up in the best possible position in the eyes of the court to be able to pursue custody in the future, not only in the eyes of the court, but also to build your case from a legal perspective?
Okay, I want to start with some questions because I need to know more information.
Sure.
You use the term custody, and I want to explain to you what custody means because people misunderstand it. Custody is a term that deals with making the major decisions.
Right.
Religion, education, health care, mobility, things of that nature. So frequently we refer to custody, but custody doesn't have to do with the schedule of where the children physically are. And a primary residence schedule in a secondary household deals with the schedule. The rest of the decisions that people make are usually decisions that are made that just go with the children being there, like bedtimes and things like that. So when you talk about custody, does your former partner or the person you're talking about have sole custody of the children, or simply primary residence?
Sole custody.
Okay, so that means they get to make all the decisions.
Correct.
And how old are the kids?
I just get informed. I don't get to necessarily partake in the decision making.
Okay, how old are your kids?
7 years old.
One child, age 7. How often do you see them?
So age 7.
How often do you see them?
Girl.
How often do you see her or her?
Tuesdays and 2 times a week for 2 hours after school and every other weekend.
Friday to Monday or Friday to Sunday?
Friday to Sunday.
Okay, so your schedule is interesting because you're somewhat set up to eventually be where you want to get to if it's equal time is your end game objective in joint custody. You have limited time right now, but the fact that you're seeing them those days, the place you want to go to is you want to start by being the best parent you can be. Most agreements allow both parents to attend at programs and activities. You should go to every program and activity. Go to every event you can at the school. If you have the time, volunteer at the school. Be a super mom, doing everything that you can possibly do to build in the time. Be very positive in the way you want to co-parent in terms of decisions. Don't make any negative statements about dad to the children.
Yeah.
If you're communicating with dad, be positive.
I would just like to say, in this situation, I wonder about sort of, I'm kind of asking on behalf of a friend, and so the friend is a male, and the friend, in this situation, feels like the court system is sort of skewed against him as a male and as a father. So I just wanted to highlight that, just because you may give me certain advice as the mother as opposed to the father. So
Well-
I just wanted to clarify that.
Well, I will tell you that probably 10 or 15 years ago when it came to schedule, I would have been more inclined to say that, but I see more and more cases where the courts are giving dads equal time. And your friend's schedule is interesting because at some point what he's going to suggest is A, Friday to Sunday should be extended to Friday to Monday. Why? One reason is better for the kids for the exchange to take place at school, less opportunity for conflict with mom and dad. Two, why should the child have to race home at a certain time on Sunday and not be able to have the benefit of waking up in the morning at dad's home? Why shouldn't dad have to participate in getting the kids ready for school? And it's good for the kids to see that dad can do things that mom can do, because it's important for them to have that kind of bonding with both children and having time to do homework with dad and the things that go in to being a parent, such as homework, programs, activities, running around with the kids, so the kids can be equally bonded with both parents. And the other interesting thing is with the 2 hours of 2 days a week, his objective should be turn it into 3 hours, 4 hours, and then why not overnight? Same reasons
It's
that I said
reduced
before.
to the point it is now. It was more before, and it was raised as a point of instability and the lack of consistency for the children, them going home too late to go to bed for school the next day.
Was
so
this
it
a
shortened from 8 o'clock to 7 o'clock.
Okay, that's 1 hour, but your friend's objective, especially as the child gets older, should be to take the 7 o'clock and turn it into an overnight.
That's what was asked for initially, and that was refuted.
By a judge?
Yes,
At a case conference or a trial?
at a case conference.
Okay. So what some people may not appreciate is when you go to court, other than a first appearance, the first time you appear in front of a judge is at a case conference. And that's where a judge will offer their views and opinions of a case. And if you don't like what the judge has to say, you can move on and take it to the next stage, which is ultimately, you'll have a couple more conferences, but it will ultimately go to a trial. And you will not have the same judge. It doesn't mean that you shouldn't take seriously what a judge says at a case conference, because it is a judge giving recommendations, and it's a lot less expensive to accept what a judge says at a case conference than fight on. But these kind of things with a return time of 7, return time of 8, overnight, there are a lot of very personal value judgments of the particular judge that is hearing that case.
And just to, as well, there's, without too much information to self-identify. There are other circumstances related to the situation as far as the children having a disability and the issues that raises as well. Also, when both parties were cohabitating within the marriage, the father was the primary caregiver. So he worked and as well took the kids outside, made lunches, did homework, took them to school. When they were when they were cohabitating, he was the primary caregiver.
But that's been
so
lost, though.
It's been very disruptive when the separation occurred. It's been very disruptive not only to the parents but to the children especially, and in consideration of their disability, because of the drastic change in who was their primary caregiver, and now the amount of time that they are limited in seeing that person.
Okay, but that's the history. There's a new status quo that's been created of mom being the primary caregiver. That may be his position. Mom probably said something different. The reality is, kids are 7 right now. So you need to build the case. Don't think you can go back in 6 months or a year. You got to build up time, because technically there needs to be a material change in circumstance. And he's going to have to put in his time, be super dad, do everything he possibly can, get as bonded as he can with the kids, spend more time, and then try it again. But if he just tried it, it's too soon.
Okay, so yeah, the final order was issued at the beginning of this year. So, and the separation occurred at the beginning of the summer in 2014. So it has been ongoing for some time, but the final order has been issued now, and that's what the framework that we're operating within. So that is, I guess, from here at this point, because it's been such a recent decision, like you said, taking this from here on forward and just building and creating the scenario, the ideal scenario, to be able to pursue that in the future.
That's right, because if you do something too soon, it's just going to seem that he's constantly coming back to court and he's highly litigious. You need to give it some time.
And to be honest, the mother is actually quite highly litigious. And also, there's been a lot of things that have been unnecessarily facilitated through her lawyer and through the court that didn't necessarily need to be, but she has pushed for those things. It's almost, and actually, this raises another question I wanted to ask. Is it possible to, I guess, pursue an action for intentional infliction of emotional distress within the dynamic of a situation like this?
That's a great question. By the way, was your friend, did he have a lawyer in court?
No.
Okay.
Self-represented and duty counsel.
Okay, so I'm going to say two things. I'm going to say one thing before I answer your last question. That's a perfect example of why it's better to be represented by counsel. Because when you're fighting about custody or the schedule of your children, framing your case in the right way can be critical to success or failure. And if you're self-represented, it can make a big difference, because you may say a lot of things that you may think are helpful but are actually hurtful to your case. Now, the second thing I want to talk about was your question, which is a great question, about intentional infliction of mental harm. There was a Supreme Court of Canada decision probably about 25 years ago. Off the top of my head, I believe the case name is Frame versus Frame. And in that case, the Supreme Court of Canada said, no, you cannot sue a spouse or a former spouse for intentional infliction of mental harm, because if you did that, you'd have spouses suing each other right, left, and center for that.
True.
The thing that I've always thought about, and I haven't seen a case for, is a child who is alienated from one parent because of the conduct of that particular parent, and then as an adult realizes the damage and the loss of the reputation between them and the parent that they missed out for years, would sue for intentional infliction of mental harm against the parent that alienated them. And I think that might be an interesting or novel argument.
That, I feel, is a more accurate description of the issue at hand. Like you said, he needs to, be an ideal parent and exemplify that. There was a situation within the past, I think, month or two, where the mother denied access for the father to attend a concert that the child was having, one of the children were having at school. And it was a deliberate action because he inquired about the concert. We were helping the child prepare for it. And when he inquired about attending, he was told parents weren't allowed to attend, but the mother attended and brought the children home after school.
Okay, so
and
did the school say to him that he couldn't attend?
pardon me?
Did the school tell him that he couldn't attend?
Oh, the mother did.
Okay, so
He
that's
didn't pursue, and this was a kind
so that's his mistake and that's his blunder. Because when you are a separated parent, you need to get all the important dates for the school. You need to check everything that's going on at the school. It's your responsibility to know what goes on. And saying they should have told you, don't put it on them because don't trust them.
We were aware. We knew about the concert, but some concerts, some of the, because it was during an assembly during school during the day. So in some of those instances, parents are not allowed to attend. It's solely for the students, and there are other times where the parents are allowed to attend.
But my point is, no,
was
don't.
trying to differentiate. We knew the date of the concert.
But my point is,
He
don't.
was prepared to attend, and when he asked her specifically,
But that's his failure.
to attend this one, he was told no.
But that's it.
her.
But that's his failure. Don't ask her.
So
Ask the school.
does that not hold to her responsibility to share information?
Sure it does, but
Primary custodial parent.
sure it does. So you send a confirming email about it. You have it on record. But at the end of the day, there's a good chance you're not going to have much that you can do about it unless you have a whole bunch of things. And what I'm getting at is avoid these problems. When you know there's a concert, don't believe what she says. Check with the school. Don't believe anything she says. Check with the school yourself. That's how you get the truth. I do have another. I do have other callers though that I do need to take their calls. So this will be the last question.
I just wanted to wrap this one point out.
Okay.
Basically, in what you're saying at that point, how much, as a non-custodial parent, how much jurisdiction do they have as far as the school? Like they're kept in the loop. He's kept in the loop to a certain extent, but at the same time, does the entire initiative rest with him to immerse himself in contact with the school?
Yes, exactly.
Okay.
Exactly. Nothing wrong with him coming in, introducing himself to the school. I'm the dad. The children are with me for doing homework. Check if the school has a website or the teachers have a website. Make sure you're on that. If there's any emails, get emails from the teachers. Make sure you're fully immersed. My kid.
They're actually supposed to be submitting documents to both parties, but have only been doing so to her.
So then how you fix that is he goes into the office. He sets up an appointment. He goes into the office. He speaks to the school about it. He says it very politely because you don't want the school to think you're being a jerk. So you come in and you say, listen, I want you to know I'm the father. I want to be as involved as possible. I know in the past I've relied on mom to communicate information to me. And as a divorced dad, I think it's my responsibility to get it from you. And I'm hoping you'll be happy to provide the information to me. They know they have an obligation to do it, but frame it in a nice way that you want to work with them.
Okay, perfect.
Okay.
Thank you so much for your help.
My pleasure and good luck.
All right, thank
Bye.
you.
Now we're going to go to our next caller. Taylor? Hello?
Hello?
Taylor?
Hi.
Hi, this is Andrew Feldstein.
Hi, how are you?
Good, how are you?
I'm good, thank you. I'm actually calling on behalf of a friend that's currently going through divorce proceedings, and I'm providing some support to him. So I'm
Okay.
going to ask the question on his behalf, if that's okay.
That's fine. Go ahead. Go ahead.
Thank you. So my friend actually started divorce proceedings earlier this year, and he thought it would be a simple application. And then afterwards, his ex actually had made some claims for child support, both retroactive and ongoing child support from 2013 and moving forward. The child is actually an adult. She's actually 22 and in school part-time. A few years ago, 2 years ago actually, she actually stopped school entirely and started working and earned around $15,000 a year. And last year she earned around that, about $14,000. And he was wondering if he would be obligated to pay child support for an adult who's 22, who's working and going to school part-time?
It's a good question. We start with, first of all, was he married or not married?
He's married.
He was married to her, to the mother.
Right. He's married to her, and they're separated
Okay.
for about
All right,
3 years or so.
that's fine. I just needed to understand whether we're dealing with federal legislation or provincial legislation, because the definition of child is somewhat different in both. So if we're under the Divorce Act, the child should be in an educational program on a full-time basis to extend child support beyond the age majority being 18. However, they could argue that the child is unable to obtain the necessaries of life on their own. So a court has lots of discretion as to whether there should be any child support or no child support. To me, it sounds like an adult, but every so often you may have a judge say, well, don't you want to do something to help your child? And sometimes you have a compromise where you don't pay the table child support, but they ask the father to kick in some money towards the part-time studies. So there's some gray area there, because there's some cases that, there's one, as an example, there's one Court of Appeal decision I always think of where the child graduates from the 4-year degree, and then the mother says, well, you worked really hard, so go take a European vacation for a couple of months. And the court says, well, still a child while taking the European vacation because the child is unable to obtain the necessaries of life. So that's where I could see some grayness in your particular case. And this is also a cautionary tale, that when someone walks into my office and they say, I have an uncontested divorce and I have a 22-year-old child in school part-time, I would probably say to that person, don't go for the divorce. Let's wait till the child gets older, finishes the program, so there's no ambiguity and your former spouse can't ask for more money. Because anytime you start a court application, it's a message to the other side when they've been served that they may want to take that application to a lawyer to take a look at. And that may create a response that you don't like.
Okay.
So, and sometimes, quite frankly, people come in to get the divorce because they want to get remarried or they're getting pressure to remarry. So they feel the need to get the divorce, but there's a very real downside to starting up, that sometimes you're better off to let sleeping dogs lie until you go to the graduation ceremony and your child is 25 years old.
Well, at the moment, the applicant, my friend, is not in a position where he actually needs to get married right now or anything like that.
It's too late now for him. I'm giving that as an example to viewers out there in the same situation. Once you've opened the Pandora's box, it's open. And now the mother is going to claim, and if he's hired a lawyer, there's going to be a certain point in time where he's going to have to choose, you know, maybe I can pay some money to make this go away that's cheaper than paying my lawyer to fight about it.
Right. He was considering paying support for the period of time when the child was in school full-time as an offer.
Well, there isn't really, well, there's two things. Number one, while the child was in school full-time, he should have paid. However, the limitation date to make a claim for child support is while the child is still a child of the marriage. So if the child is no longer a child of the marriage and you never made a request, then you don't have to pay. The problem is some people will view the law as you have to start the application. I believe it's the date you first make the request, even though if I'm acting, I'd rather do the application. So then there's a question of, was there a request made? Somebody may be able to produce an email, or will the court accept the person who wants child support saying, well, I asked him for it a bunch of times in a text message that I don't have anymore. And will they say that's enough? And they might. So there's some risk there.
This is the one that made the application, and we're wondering why she took so long to even make a claim. She's never once asked for support. We don't have anything documented in email, text, or in writing, or they never even had the conversation about support.
She's going to say that she asked him over the phone, she asked him at functions, she asked him in text messages, and she doesn't have them. The problem you face is child support is considered the right of the child and not for her to waive. So there's a lot of sympathy for child support. Now, if he did pay for things during that period of time, he should be adding up everything he paid for, because sometimes what you find out is the argument as to why somebody didn't pay a table child support payment and why the other person didn't ask for it is the father just paid for a bunch of stuff. So, for example, the child came and said, Dad, I need money to pay a bunch of bills. Dad, I need money. Dad, I need money. And if Dad wrote checks or did bank transfers, and he has a record of what he gave the child, you may find out it exceeded his child support obligation, and he's going to say, well, I want credit for all those payments. And the reason why she never asked was she knew I was paying for all these bills.
What if he's paying for bills for something like car payments, but not something that was directly like linked to the child? But I mean, they would have used that.
Well, that becomes debatable, and his point is, well, that was the deal we had. The deal we had was she needed a car or he needed a car to go to school or to go to work, so I paid for the car.
Right.
And had she asked me for child support 3 years ago, it would have been really prejudicial to me because I never would have paid for the car. I couldn't afford both.
Right.
You know, and then a judge thinks, well, maybe that's why there was never the request made. It's very different when somebody is actually, in my mind at least, when somebody is paying bills for their children and thinks, well, I am contributing to my child, versus someone who just sits there and says, I'm not paying.
Right.
The optics are different. So if he's made a bunch of payments, he should look into getting the proof of what he paid.
Okay. Proof of the car payment.
Proof of the car payments and whatever other bills. Maybe he put a bunch of charges on a credit card. I mean, I look at it this way and I say, if I have a daughter and I go to Claire's as an example, and I bought it, even though I can't imagine doing this, and I drop $500 at Claire's, it's pretty obvious I'm not shopping at Claire's for myself, and I'm not going to be shopping at Claire's for my partner, because somebody in my age bracket certainly isn't going to be shopping for themselves at a place like Claire's. So you can also pinpoint where you went shopping may be totally inconsistent as a payor.
Right.
Right?
Right.
Or if my child was in competitive hockey and I'm not playing hockey anymore, and you see a bill of $2,000 on hockey equipment. Well, who is it for?
Right. Okay.
So you got to go back and look at the credit card bills and think about certain things, what was paid for, because seeing what you paid for may be very clear it was for a child and not for you, and not for somebody you're with, because obviously the argument's going to be if it wasn't for you, it was for your girlfriend or your new wife or your new fiance.
Okay, well, thank you very much. I really appreciate the information.
My pleasure, and good luck.
Thank you. Have a good
Bye.
evening.
Okay, next I'm going to move to a text message. Oh, sorry, I see we have a caller on the line, so I'm going to move to that caller. 1 second. Hi, Kathy. How can I help you?
Hi, thank you for taking my call. My question is actually for a friend, and it involves inheritance. There is a family cottage that is being willed to my friend by his father. Now, his father is still alive. My friend and his spouse have used the family cottage regularly every summer for many years. So what my friend is wondering is if he should inherit this cottage before they work out their separation agreement. They're in the process of that. Will his spouse have any claim on this? And also, if he inherits the cottage after the divorce and everything is settled, will his spouse have any claims on it?
So let me understand this. Your friend's parents are still alive, and the cottage is in his parents' name.
That's correct.
Okay, so it's not his asset. So there's nothing.
Presently, no.
Yeah, so there's nothing for the former spouse to claim against, even if she used it every weekend, because it's her in-laws' cottage. The in-laws could change their will today, tomorrow, or did it yesterday. There's no claim. There's nothing that they can.
Is it could be considered like a second marital home because they vacation there every summer?
No, I don't see that happening. I don't see a court making an order for exclusive possession to her or anything like that. I think the greatest risk is if they put a lot of money into the parents' cottage, of her trying to say there's some form of beneficial interest in it. You take the scenario, let's say I have a huge cottage that's 3 acres in Muskoka, and one of my children says, Dad, I like staying in your place, but I want to construct my own home, and they go spend $1 million constructing a monster cottage. Well, there's an easy extreme to show they would have an interest in some value because they really enhanced it. But assuming they didn't do anything to enhance the cottage, she doesn't have anything, and they've separated it.
It doesn't matter, no matter how much time she spent there over the years?
No, the scenario that you're really concerned about is, let's assume for argument's sake, that your friend's parents had passed away during the marriage. And had they passed away during the marriage, and your friend had inherited the cottage and used it June to September every weekend as a family cottage, and both spouses came up there, what people don't appreciate sometimes is that there can be more than one matrimonial home. And that cottage could be a matrimonial home. And even though the Family Law Act says if you get a gift or inheritance and you can trace it to the date of separation, it gets excluded, meaning not from the calculation of NFP, which means that you don't share in it. However, if that gift or inheritance went into a matrimonial home, you do have to share it. And at the end of the day, that cottage property, if it's being ordinarily used by the family, would have to be shared. But he never got the inheritance because mom and dad are still alive.
Right. But God forbid, if they were to pass before they come to some sort of separation agreement. And
It doesn't matter. They've separated.
Yeah.
It had to be a matrimonial home on the date of separation.
They're in the process of working things out.
Yeah, I don't see that because he didn't have the asset on the date of separation. When he fills out his sworn financial statement showing what he had on the date of separation, he didn't own the cottage. He had an interest in absolutely nothing.
Okay.
Because
Right. That's very helpful.
lots of people are beneficiary or are potential beneficiaries of an estate. It doesn't mean that you've never heard of situations where a parent is mad at a child and writes the child out of the will. Your friend could have done something to anger his parents tomorrow.
Right.
And the father could have gone down to his lawyer and written the son out.
So
Right.
until he actually has it, in his hands, essentially, or
Until he's the owner of the property, there's no ability for her to have any claim unless she's somehow making a claim that she put enough money into this property to enhance it, that she should have a beneficial interest in it. And I think that's a stretch unless she put real money into it, because I think judges get it. In fact, some judges are the ones who have the cottages, and judges are usually, I like to say, older than me, but some now are in my age group. But the judges who are in their 60s and 70s have kids coming to their cottage with their spouses. And they're going to think in their mind, wow, could I picture my daughter-in-law or son-in-law making a claim against my cottage? It won't make it into their reasons, but you can imagine that they're going to think of what precedent they're setting for their own cottage and thinking of how ridiculous it is. I'm being nice to let my daughter-in-law come and use this cottage every weekend, and now she's going to say she owns it because I let her use it?
Okay.
All right, I hope that helps, and sorry to keep you waiting before.
That helps a lot. Thanks, Andrew.
Okay, have a good day.
You too.
Bye.
Bye-bye.
Okay, now we're going to move on to the text messages we've received. And I believe, that text message actually was from Kathy as well. So I'm going to move on to an email that I have. And here's the email. My father is leaving me, same topic. So it looks like the text message and the email were the same topic. So I'm going to move on to some of the questions that I received since the last show. And that's, the first question is, and this is something that I was asked last week by the Toronto Star. How private will my divorce be? Last week, I saw a big front page story in the Star, here it is in my hand, with all kinds of personal details about the divorce proceedings of a businessman and a wealthy woman, member of the McCain family, so that gives you an idea of how wealthy. I'm not a celebrity, but I am well known in my profession, and my wife has a reputation as a community leader. What can nosy people find out about our personal affairs? This may shock people to hear, but they can find out almost everything. Because if you have a court application, you're going to have all sorts of personal information in it. You're going to have your date of birth, your children's date of birth, your spouse's date of birth, maiden name of your spouse. You're going to have all the nasty, salacious details of your marriage may end up in the court application and the answer. And in addition to that, you're actually going to file a sworn financial statement that lists all your assets, all your liabilities, where you bank, your bank account numbers, your credit card numbers. Some lawyers, like our firm, we won't put all the numbers in, we just put a few digits in. But some lawyers will put all of the account numbers in. In some cases, you may even be able to see people's SIN in the court file. All of that is in your local courthouse. And that allows you, if you're a nosy neighbor, to go down to the courthouse and read that court file. And even more, if you want to pay an outrageous fee of, I think it's $1 or $2 for a photocopy, you can actually photocopy the entire court file. I mean, I know I've spoken to real estate agents many times, and I don't understand why they don't do this, but when you know that some people are going through a divorce and a house is for sale, I've often said that they should go to the local courthouse and get all the financial information. I know when I've been in a situation where I'm buying a home, I check to see if the parties at the courthouse are going through a divorce, and I actually want to see. I haven't had the good fortune of buying from somebody who's going through a divorce, as sad as that may sound, because I wanted to see, did they have power to stay and wait when they're selling the home, or were they desperate to sell? Sometimes a court file will even tell you that there's a court order for the sale of the home and the minimum price that they have to accept in order to sell. Just imagine them buying a house if you know what price you need to make an offer at so that they have to accept, providing there's no bidding war. So it can be quite shocking. And if my former spouse knows that I'm a celebrity and wants to make all sorts of horrendous comments about me, they can. And they can totally destroy your reputation because newspapers can repeat it saying, this is what was stated in the court file, and quote it. Now I have another text message that came in, and it says, I have 43% access and have been asking for 50% from my spouse. I'm going to trial in November over this item. 3 different judges have given their opinion of set-off in regards to support. What are the chances a trial judge will say full support? I have my children from Thursday after school till Sunday at 5 o'clock every week. It's an interesting question, and people need to understand what's behind this question and what it means by set-off. If you have your children for more than 40% of the time, and both parents have the children for over 40% of the time, the guidelines say it means you're sharing. And if you're sharing, you have to do something called the Section 9 analysis. Section 9 of the Child Support Guidelines, which deals with the situation with both parents share time. And when you do the Section 9 analysis, there's a Supreme Court of Canada decision called Contino. And Contino says that you start with the set-off. That means if the father makes $100,000, you go to the guidelines, you see what the guidelines say he's supposed to pay for the number of children he has, and you do the same for the mother. And whoever has more pays the difference from the one who has less. But Contino says that's only the starting point. Then after that, you have to look at the conditions, means, needs, and other circumstances of the parties, and you have to do child care budgets. And at the end of the day, I can tell you this much. I don't know what all 3 of the judges said in this particular case, but if you ask 10 family law lawyers, most of us are probably going to shrug our shoulders and say, we really don't know where the numbers are going to add up, and there's going to be certain fact-specific scenarios of your case, but it will end up anywhere between the set-off and the full table child support. And what's really important for you to appreciate to the person who texted us is do a cost-benefit analysis of what the trial is going to cost you if you're represented by a lawyer, the risk that if you lose what you've paid your lawyer, and if you lose you may end up paying costs, which would be the other side's lawyer as well, over how much money you're fighting about in the set-off. So there can be a lot at stake in those situations, and you have to do a cost-benefit analysis, and you may need to make a compromise because you may not want to roll the dice. I always remember one judge in mid-trial took me and the other lawyer into his chambers, and he says, I live in a city called Aurelia, and we have a gambling place up there called Rama. And he said, I don't know if your clients are gamblers, but that's what they're doing with this case. And when you're fighting about set-off or not set-off, you're basically going to Rama and rolling the dice with your chances. And you may get the case in just how you want, and you may end up losing. Probably not what you want to hear, but that's the reality. Now I'm going to go back to one of the questions I got from the Star during the week, and this will be the last question for today's show. What happens when different kinds of relationships end? This isn't a question from a viewer. It was asked last week to me by a reporter for the Star, working on a story, the same one I mentioned before that's been dominating the news lately, or at least divorce news. and here's what she asked me. Does the fact that you're married affect who gets what? Absolutely it does. If you're married, you're entitled to a division of net family property, like we've discussed several times during the show. If you're living common law, you're not entitled to an equalization of net family property. And if you want to share in assets, you have to be able to establish that you either have a resulting trust interest in the assets, a constructive trust, or that there was a joint family venture. That can be, in some cases, very litigious and time-consuming and costly to achieve that, whereas if you're married, you got the entitlement of equalization of net family property. The thing that's been in the news is about an annulment, and if you are able to annul the marriage, which is extraordinarily difficult, the marriage never existed, and there is no payment. Okay, now, I believe I answered all those questions, so I did it faster than I thought, so I may have time for one more question, because I got quite a few, and I'm trying to pick one that I think might be interesting. School fees and grandparents. I'm negotiating a separation agreement with my wife, and we're not sure where her parents can fit in. Our 2 kids go to private school, but we think we can not afford this now, and we have 2 complete sets of household expenses. Her parents are generous and love their grandchildren. My wife's lawyer suggested the grandparents set up an annuity to pay the private school fees and perhaps even college or university. That would be earmarked to cover my wife's share of school costs. I'd be responsible for uniforms, school supplies, and trips, and so on. Would a judge allow this? Well, that's for the benefit of the kids. The judge is going to allow it. The real question is, there's no obligation on the grandparents to do it. And do the grandparents want to do that? Do the grandparents want to set up the annuity? And you want to be very clear that if the grandparents are doing something, that the benefit should be gained by the child of the grandparents when it comes to paying for extra expenses like university and things like that. That was a quick answer for that one, because we are just about out of time now. And I wanted to say we're now close to the end of the March edition of Ask Andrew. I hope you've enjoyed the show. I certainly think it's been a great show. Not only were there interesting questions today reflecting of your own lives, and it seemed like a lot of friends of our callers, but I know that many of the people in our internet broadcast audience found lessons for their own situations. I know whenever I'm hearing people discuss divorce, I reflect as it compares to my cases, and as well to my own personal circumstances, since I'm also divorced and have the pleasure of paying support. We'll be back in April with the next Ask Andrew show. Please remember, if you have questions about family law, we have 3 websites that offer you the most up-to-date information. And for you, the viewer, the most important part may be that it's free. Separation.ca is our main website for the Feldstein Family Law Group. It has explanations of the process of working with us on a family law matter. Plus, it has many articles and blogs, including videos that explain various aspects of family law. We believe this is the largest family law website in Canada. That's separation.ca. Another site is familylawhelp.ca. This site explains the entire divorce process and is designed to help visitors who might want unbundled family law services. Unbundling, as I mentioned earlier during the show, is a process where someone looking to get separated or divorced does some of the legal work themselves and asks a lawyer for help on other parts. An unbundled services client might, for instance, draft agreements explaining how they want a settlement to proceed and then pass it to a divorce lawyer for review. Or you might determine what points you want a judge to understand and then ask an experienced lawyer to actually stand up for you in a courtroom and offer convincing words. That's familylawhelp.ca. And you need to understand what it allows people to do if you have a very specific, I'll call it litigation budget. It allows you to try and target your litigation budget and get the biggest bang for your buck. And our third website is designed to improve access to justice for everyone going through separation and divorce. Access to justice is the phrase we use when talking about cutting costs, cutting time, and cutting through the bureaucracy in family law. In fact, I also consider this show trying to help the public with access to justice to get a better understanding of family law, whether they're self-represented or not. I've published 2 white papers about divorce law, and we've received many comments about how they help build build understanding of why costs are high and what can be done to reduce them. A third paper about the difficulties of representing yourself in a family court will be published this year. This site is called itstimeforjustice.ca. Thanks for tuning in tonight. We'll be back in about a month. Good night, everyone, and I hope you enjoyed the show.